Guys, welcome back to my channel. This is Batok with Ola. My name is Mujela Olua. Thank you so much for tuning in once again. I got a question today and I want to do a quick video on that question, because I have a lineup of other topics that I want to do, but I do not want, that video to stay too long undone. That's why I want to do that one today. I got a mail from a subscriber or a viewer called Anastasia. If you have not subscribed, please kindly subscribe. Thank you so much. And she asked a question which I want to respond to. Let me read the question out. Good day to you, I'm Anastasia, and if you do not mind, I have a few questions to ask on the conduct of criminal trials. It's been said that filing of witness statements on oath is not obtainable in a criminal trial. How then do counsel for both the complainant and defendant tender documents, if any, and prepare for cross-examination of witnesses? So here is how criminal matters, are conducted, especially the litigation part. You see, when the police has forwarded a duplicate case file to the Office of the Director of Public Prosecutions for his advice on whether the accused persons, the defendants now, they are defendants already because they must have been arraigned at the magistrate court and remanded by the magistrate pending the advice of the DPP, that's the Director of Public Prosecutions. So when the advice is out, the advice will tell whether they are to be charged at the High Court or at a higher court, or if a more appropriate, organization or agency should take up the prosecution. For instance, if it's a drug trial and it's going to the office of the DPP, might advise that this is an NDLA matter, so let it be forwarded to them for appropriate actions. So it could be like that. But once the duplicate case file has gone to the office of the DPP, you have to wait for advice to come out on whether the accused persons or the defendants are charged or not. The DPP will charge them based on the evidence in the duplicate case file. That is the police investigation. So the DPP will basically consider if the investigation discloses a course of action. That is, if it discloses a crime that's been committed, and if the defendants have been sufficiently, linked to that crime, and then they will prepare a charge, which is called a complaint at the High Court. When the DPP has advised that the accused persons be charged, he will file a complaint. That is, his office will file a complaint. That's the charge, called a complaint at the High Court. At the High Court, that will be filed at the High Court. It will contain the proof of evidence. So the charge that is filed by the prosecution contains, number one, a page that says that this is the complaint filed in this matter, so and so and so. Then number two, it discloses the charge. That's the charge sheet itself. I've done 2 videos on charges on this channel. Please do well to watch them. I'll link them in the description box. So the charge sheet itself saying that, that the accused person has been charged for so crime contrary to and punishable under section so and so of the criminal code, of this state law, of that other law. So then it will now contain, attached to it also will be the proof of evidence. That is the list of witnesses that the prosecution intends to call, the list of exhibits that the prosecution intends to tender, that is objects and what have you that were seized, at the scene of crime or recovered during investigation, as being tools that were used in the crime, or maybe the loot, the booty that was being carted away, or being the subject of the target of the crime. Okay, so those things are exhibits, yes. So there will be a list of witnesses and a list of exhibits. That's part of what will be filed alongside the charge sheet and the complaint paper. And then there will also be the defendant statements made at the police station, usually in the presence of his lawyer. Then attached to it will be the defendant statements, that is the accused person statements or statements made at the police station. Every statement made will be attached, after the list of exhibits and the list of witnesses. And then the complainants, that is the person that complained, if there's a complainant. Usually the state is the complainant in criminal matters before the High Court, but also there's a nominal complainant, that is the person that was affected by the crime. If it's rape now, the victim is a nominal complainant. If it's robbery now, the owner of whatever was carted away, or maybe the owner of the establishment that was robbed, the house that was robbed, the people that went to the police station to make a report, they are the complainants, the nominal complainants. So their own statements that they also made at the police station will be attached. That's part of the proof of evidence. And then the statements of the prosecution witness, That is, everyone that went to the police station to talk about what they saw or know about the crime when it was committed, or everyone that the police spoke to who made it to the station to write a statement during the course of the police investigation. Their statements will also be attached. They are called witnesses, and they are prosecution witnesses, because the prosecution will bring them to court in support or proof of their case. So their statements are also attached. These are the things called the proof of evidence, and they are filed by the prosecution. The defense need not file anything at this stage. So once all those things have been filed, and then the administrative judge has assigned the case to a court, and a date has been set, the case will be called for mention. You can watch the video on how crimes are prosecuted. After it's been mentioned, it will be adjourned for a hearing usually. So when it's adjourned for a hearing commences criminal trials through arraignment. Arraignment is when the accused persons take their plea. That is the first time that the court will read their charge against them to them, and then they would ask them if they are guilty or not guilty, and then they will say guilty or not guilty, or whatever other plea they want to make. I've done a video on arraignment. Please do well to watch it as well. I'll link it in the description box. So after the arraignment, trial will commence. That commences by the prosecution calling its witnesses in proof of its case. Usually the IPO is the star witness for prosecution. That is the investigating police officer. He is the one that conducted the investigation even before the matter went to the magistrate court, before it went to the director of public prosecutions and every other party. Is the one that conducted the investigation. Is the one that knows so much about the case by virtue of his office as the officer that looked into the crime when it was first reported, or when they were first notified, or when they were first notified of such occurrence. So the IPO is the witness, the prosecution witness, and then the nominal complainants too are called as witnesses. If they refuse to show up, it does not really mean that the case will die a natural death, but because the state has now become the chief complainants in the matter. But the nominal complainants are usually also called as witnesses, and then every other witness that made a statement will be called as witnesses before the court, and usually they come to give witnesses as to what they saw or know about the case, and especially what they have written down in their witness statement or no. So usually the practice is that the prosecution will tender the IPO statement or his report of what he did, what he conducted, the investigation that he conducted, and then they will tender the defendant's statements that were made at the police station. So those are the things, the documents that the prosecution usually tenders. So it's up to the defense to decide if they want to tender the prosecution witnesses' statements or the complainant's statements. So prosecution need not tender those statements, but defense can tender it so that they can cross-examine the witnesses and the complainant on those statements. But it is not mandatory, and in fact, it's somewhat improper for the prosecution to tender the statements of their own witnesses. Yes, so that is how documents are tendered in criminal trials. To go back to the question, the state files all the documents that will be tendered in the matter. The defense only needs to show up for defense, announce their appearance, and enter into trial. And then they can request for any document from the prosecution, documents that are already before the courts. And then they can request for any documents that they want to tender from the prosecution. Or if the prosecution has already tendered it, they can then examine or cross-examine on those documents. But the burden is not on them to file any witnesses' statement on oath or anything. That's the job of the prosecution. The prosecution will file all the statements of accused persons or defendants, of the complainants, the nominal complainants, of the IPO, and of all other witnesses in the matter. And then they will tender the ones that they are supposed to tender, and then the defense can also tender what they want to tender by asking for such documents, the proper versions of such documents. For instance, the original copies of public documents or certified true copies of public documents and what have you, like statements of statements that were made at police station, statements of the witnesses of the prosecution. So they can ask for those documents in court from the prosecution so that they can tender them, or if the prosecution has already tendered it, they can then make recourse to it or reference to it during their own examination or cross-examination or re-examination, so that they can ask questions of any witness whom they are questioning on such documents. I hope that this answers your question. And when parties are done with their examination, with the prosecution's examination, cross-examination by defense, re-examination by prosecution, and with the defense's examination in chief, cross-examination by prosecution, and re-examination by defense, matter will be adjourned for adoption of written addresses. Both parties will exchange written addresses within 21 days. So in 42 days, they are to come back to court to adopt the written addresses that they have both written and exchanged and filed in court. And then the matter will be adjourned for judgment. You know that the constitutional requirement is that judgment must be delivered within 90 days of adoption of written addresses. There's a caveat, however, and it is that if actually the defense has any other document that they want to tender, or they want to question or examine a witness on, they can bring it to court and tender it. As long as it is relevant and admissible, it will go into evidence, and then they can question or examine on that document, and then the prosecution can also make reference to that document and question the appropriate witnesses on it. But as for the initial documents, especially witness statements, as asked in this question in the email that Anastasia sent to me, only the prosecution files statements in court in criminal matters. I hope I've answered your question. I will see you all in my very next video. Toodles.